I didn't understand the assignment news. The Department of Child Safety is being sued because it placed the children it took from unfit homes into a foster home that ran a abuse ring. So, didn't understand the assignment. Took the kids from dangerous homes, put them into a house that runs a child ring. Fantastic. We'd like to sue them for, doing this. And of course, they're over here with qualified immunity. I had no idea. Was I not supposed to do that? Was that wrong? If anyone had told me I was not supposed to place the children into into abuse ring, I would have done it immediately. Yeah. Let's learn more about this. Let's learn more about this story. The state of Arizona is arguing that it should have qualified immunity from a federal lawsuit seeking it to hold it liable for placing the children who were in further harm's way, by putting them into a foster home that forced them into a salacious abuse ring. Well, this is going really great. Out of the frying pan, into the fire, out of the dangerous home. How about forced child prostitution? Great. Going over really well over here. The individuals are suing the state agencies and officials for placing one of their siblings and themselves into foster care with a former civilian military leader named David Frodsham, who is a noted abuser, who is now serving 17 years for leading the child ring. So, not maybe the best person to oversee the children. In addition to exploiting the children, authorities say the conspiracy put national security at risk by making the individual, who is a military leader, subject to blackmail. So, yeah, maybe some people were exploiting him for information because they knew some deep, dark secrets. The Associated Press found that Arizona and the U.S. Army, for their part, might have had some clues that all was not well, but decided not to look into it too much further. Why would we look into it too much further when we had all these red flags? I like red flags. Red is a nice color. Let's keep going on. Arizona has received 20 complaints of misconduct against the individual and his wife, but even though it had received 20 complaints, it already had 20 complaints in hand against David and his wife. 20 complaints. It still allowed them to serve as foster parents to the individuals who were suing. 20 complaints. 20. They had 20 complaints against them, and we see nothing wrong. Let's continue putting the children with this wonderful, wonderful couple. 20 complaints? 21 is our magic number. We haven't reached the threshold yet. The Arizona has attempted to deflect blame to its contracting agencies, which it says investigated relevant complaints, but deemed them unfounded. Well, I feel real sure there. Someone actually took the time to report 20 instances of misconduct to the government. The government looked into it and says, we see nothing wrong. The individual who is suing, who is now 20 himself, alleges that the foster parent abused him over a period of 12 years. 12 years of abuse of a salacious nature. 12 years it went on with him in the foster care. It only ended when the guy was arrested in 2016. When the guy who was suing was 13 at the time. Because that's how math works, right? So the guy alleges that he was abused from the age of 2. From the age of 2 for 12 years. Great. And the agencies that place the children in the foster care, are they suing them for negligence, emotional distress, assault, and battery? Going super, super well. In November, Trevor moved for partial summary judgment. Arizona argued qualified immunity. We had no idea. We had no idea that should we not have done that? Was that wrong? You can't sue us for putting the 2-year-old with the 20-time accused person. I mean, who could have possibly seen a problem with that? The Grand Canyon State says its caseworkers believe the foster care placements to be in the best interest of the child. Wow. Well, one of two things is true. Either we have the most perverted definition of best interest of the child ever, or we're not very good at determining the best interest of the child. I'll let Arizona pick which of these universes it prefers to be in. And the decision was merely an exercise of professional judgment. Just the minor oopsie doopsies, any professional can make this mistake. There's no reason a caseworker should have qualified immunity, argues the Arizona attorney who represents the people who are, abused since the age of 2. They say that caseworkers are sometimes in a tough spot and may have to make tough professional calls, but I'm not exactly sure that this is one of them. The lawyer who is suing says that qualified immunity should be limited to situations in which caseworkers approve or revoke foster licenses, and it's inappropriate to shield states from negligently placing a child or failing to investigate a complaint. Qualified immunity began as a judge-created nightmare concept that limits legal liability for government actors. Arizona, for its part, codified qualified immunity into statute, which specifically grants immunity for decisions relating to foster care licensing and certification. Dude. What a nightmare. Oh my God. They actually codified in the statute. Oh my God. Am I going to actually have to rule for Arizona on this one? Life sucks. The state argues even if it's not entitled to immunity under statute, it's entitled to qualified immunity as a common law defense, and announced the claims is nothing but a vain attempt to remove plaintiffs' claims for qualified immunity protections of the statute. A vain attempt? Wow. I mean, damn. You have no love lost over here, do you? I mean, these little children were taken care of for 12 years. Why are they complaining? Qualified immunity grants government officials immunity unless they can show they were deprived of a right, and more importantly, that the right was clearly established, which anyone who is familiar with this channel knows how difficult that can be. Yeah. The defensive doctrine has frequently faced criticism in all kinds of cases. Supreme Court Justice Thomas has called for complete overhaul as the concept's use has strayed afoul of whatever intent it might have had in the first place. Yeah. The sad thing about this is I know, and you know, that the state has a pretty damn good chance of winning. And there's nothing I can do about it. That's how much this goes. Shit. In court documents, Arizona calls the position on immunity bizarre and misguided, and says it amounts to a request the court ignore decades of case law and adopt an unprecedented narrow view, which would render the statute meaningless. Sadly, Arizona's probably not wrong. By contrast, the victims' lawyers argue that benefits of extending immunity are outweighed by risk of subjecting children to potentially devastating and lifelong damages. Accountability is important, says the person who was victimized in the court filings. Counsels for parties did not immediately respond to comment. That brings us to the end of the case of David Frodsham, and more importantly, the Department of Child Services, who decided to take at-risk children away from whatever homes they had and put them into the child abuse ring for many, many years, starting at the age of 2, even though there were already 20 complaints. The state argues qualified immunity. The state is probably right. I don't like qualified immunity very much. Whatever point it had, it has long since exceeded. So Arizona I would bet, is going to win. So a depressing outcome to a depressing story. Sorry for the 12 years of abuse. You have no remedy. Wow, that's great. That, for the moment, brings us to the end of discussion of this story.